Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, y'all. Welcome back. Welcome back. We are here to get into another video. Now, we're going to continue on with our conversation that was being had in the previous video. Now, I'm going to link the video here. However, the prior video that I am having a conversation about is Demoree versus Desiree. All right, this is daughter versus mother in legal battle. Now, the prior video that I made was about the Medical Malpractice Act, and we're here to get into the RICO claim. All right. Now, if you do not know what I'm talking about, I am going over the Omnibus order that dropped on October the 8th of 2025. Now, to actually get into it, Judge Bloom issued an Omnibus order on October the 8th of 2025, dismissing over a dozen claims, including RICO, negligence, and several IIED counts. Now, IIED stands for intentional infliction of emotional distress, okay? Claims tied to civil conspiracy, false imprisonment, and federal wiretap violations will proceed against Desiree Perez, Barber, Sig9, and others. Claims against CTS Research, ROC Nation, Iconic, Anderson, the District, and Lifeskills were fully dismissed. All right. Now, before we get started, if you are following me on X, formerly known as Twitter, then you know you would have seen there first. However, top left-hand corner of your screen, that is my QR code that will get you directly into my X, formerly known as Twitter page. I have a plethora of other court cases that I am also looking into. You can divulge in everything real time. When I post it, you see it. All right. So that's that. Now let's get into my copyright disclaimer under Section 107, simply saying that, hey, this is fair use. I am not a paralegal. I am not an attorney, and I am also not a judge. I am simply saying that, hey, I have common sense and I know how to read. And if you want to donate, there is the Cash App right there, Document Tingz. Now, without further ado, let's go ahead and get started. Now, I will have the court document linked in the description box below. Also, again, top left-hand corner, QR code, X page. Now, we are on page 18, okay? We've already looked at this argument right here, Medical Malpractice Act. I've already went over that. So we're going to get into the next thing, which is count one, the RICO claim. Pursuant to 18 U.S.C. 1962C, it is unlawful for any person employed by or associated with any enterprise in or the activities of such effect, interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering activity or collection of unlawful debt. To recover under Section 1962C, a civil plaintiff must establish that a defendant, 1, operated or managed, 2, an enterprise, 3, through a pattern, or 4, of racketeering activity that included at least 2 racketeering acts. And as y'all can see there, that is a quote from another court case. All right, so let's continue. A plaintiff must plead a defendant committed a pattern of RICO predicate acts amounting to racketeering activity. A civil plaintiff must also show the requisite injury to businesses or property, and 2, that such injury was by reason of the substantive RICO violation. Perez argues that plaintiff's RICO claim fails to meet the elements. Specifically, enterprise, and pattern of racketeering necessary to allege a RICO claim. Plaintiff responds that the amended complaint contains sufficient allegations to assert a RICO claim to show Perez used her money, power, and influence to tear apart the Hadleys. A plaintiff contends that the following predicate acts support her RICO claim. 1, kidnapping. 2, bribery. And 3, wire fraud. The court need not address whether the amended complaint alleges an enterprise because plaintiff has failed to sufficiently allege predicate acts required to establish racketeering activity under 1962C. Absent any valid predicate acts, the plaintiff cannot state a claim for RICO violations. A pattern of racketeering activity requires at least 2 acts of racketeering activity, 18 U.S.C. 1962. To show a pattern of racketeering activity, plaintiff must first plead that Perez engaged in 2 or more predicate acts. Second, the predicates acts must be related or have similar purposes, results, participants, victims, or methods of commission, and the pattern must reflect a threat of continuing racketeering activity. The phrase racketeering activity is defined as including any act which is indictable under a lengthy list of criminal offenses. And as y'all can see there, they're quoting a long court, a different court case there. Here, plaintiff's conclusory allegations fail to assert predicate acts. The amended complaint asserts that Perez unlawfully committed wire fraud by using electronic communications to defraud or executed a scheme to defraud, robbery, witness tampering, kidnapping, and or false imprisonment, forcing Demoree into a truck, and other criminal acts affecting interstate or foreign commerce. The mere identification of the predicate acts plaintiff seeks to assert is insufficient to state a cause of action. Indeed, the courts have long recognized that while legal conclusions can provide the complaint's framework, they must be supported by factual allegations. The facts alleged in count 1 are that Perez forced plaintiff into a truck and had a plan to cheat plaintiff out of job opportunities and cause her to be totally dependent on Perez. Offered, gave, or promised something to Barber, intentionally tampered with plaintiff and Javon as witnesses to legal proceedings, and caused plaintiff to be detained. Plaintiff fails to connect how the few factual allegations mentioned constitute wire fraud, robbery, witness tampering, kidnapping, and or false imprisonment. Accordingly, count 1 is dismissed with prejudice. And that is that. All right. Now, next, we're going to get into, as y'all can see right here, counts 2 and 3, which will be civil conspiracy. And as you already know, when it comes down to civil conspiracy, that will proceed to trial. All right. If you like what you see here today, like, share, and subscribe. And until next time, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, talk to you soon.